Right from the start, this case takes a strange turn. What begins as a routine courtroom matter quickly spirals into something far more disturbing. The real question is, how did a series of letters escalate to the point where a judge had to step in? Stick around, because the details behind these messages reveal a situation that's far more serious than it first appears.
Docket 25516-C, People of the State of Michigan versus Siobhan Hanks. Counsel, your appearances for the record.
Good afternoon, Nicole Matusco on behalf of the people.
Good afternoon, Your Honor. Jacob Starks, the fourth assistant public defender, here on behalf of Mr. Hanks. He's present at the podium. He's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. This is a motion to reduce bond. Is that correct?
That's correct.
Prior to this, sir, however, you seem like such a nice young man. I read your history. It's not the worst, but you have a few things that are not so nice as well. What is troubling to me, before we even get to this motion, is that I do not let anyone, and I mean anyone, disrespect a public defender, disrespect a prosecutor, law enforcement, or anyone in my office. I have a staff of letters that you have written to our prosecutor, who does an outstanding job. I would read to them to remind you of the disrespect that you're.
This is where things get wild. Courtrooms deal with strong emotions all the time, but sending outrageous letters directly into the legal process crosses a serious line. Judges and attorneys treat written threats or harassment very seriously, because those documents can become official evidence. The big question here is whether these letters were just reckless venting, or something that could actually trigger criminal consequences.
Shown. Here's a letter that starts out, "Hey, bitch Matusco, it is Siobhan Hanks writing to again. This case has been going on for over 13 months now, and still not a plea deal been offered to me." It goes on. Here's another letter. "Hey, bitch Matusco, this is Siobhan Hanks writing your bitch ass again. Still no motherfucking resolution. How, bitch? It is not hard for you to figure the fuck out what you want to do with me, bitch Matusco. This case is petty as fuck. This case is so fucking frivolous, okay? Yes, I know I did something wrong, but this is not some type of big case. This is not an average armed robbery. All I did was use a punk-ass BB gun to take a punk-ass dab pen and a punk-ass breeze while I was high on multiple different drugs. Bitch, stop playing and give me rehab with probation. Do not even offer me any prison time because I am not taking it. So with that being said, bitch Matusco, I need some type of plea deal with no more upfront jail time immediately." Goes on to talk about other things about the plea deal, and then said, "I did shit to people who did less than what you are doing. So fat funky bitch, hurry the fuck up. It is time we wrap this case up. And when you bring these letters up in court, mention my reason for them. Oh yeah, I do not give a fuck about you reading these letters in court. Go ahead. I want you to. No fucks is giving." Oh, it doesn't stop there. I do not know why the fuck you have not dropped my charge down to unarmed robbery or larceny from the person I truly did learn my lesson. Nobody got assaulted. I was high on a few different drugs at the time of the incident. I only did that for a breeze and dab pen. I clearly have a drug problem. I have over a year of jail time served. I am open to accepting rehab and intense probation, bitch. Again, more vulgarity. I do not give a fuck about you telling the judge about these letters. The fuck you can show her shit. You can read this shit in courtroom for all I care, or should give me all letters I wrote you, and I'll read them in court.
At this moment, the tone in the courtroom shifts completely. What might have seemed like a joke to one person clearly isn't landing that way with the court. And in legal settings, intent matters. but impact matters even more. So let me ask you, if someone claims they were just joking, but the court sees it as intimidation, who should the law side with?
With a big smile. I don't see you smiling now, sir. And I suggest you don't, because this isn't very funny. I am not as scared of you, nor the rest of them crooked bitch-ass prosecutors that work at your office, including y'all master, John DeWayne. Oops, let me check myself. I mean, bitch DeWayne. Y'all can suck the cum on my big black dick off every business building on Kalamazoo Street, along with the whole Michigan Avenue bitch who trying to send me to prison over a BB gun, breeze, and dab pen. The victim was not assaulted. That shit is not worth any prison time. And it goes on. You owe the prosecutor an apology. You will not write these letters. You do not have the right to assault verbally the prosecutor or your attorney or anyone in this courthouse. None of us are in handcuffs. You are. You need to check your attitude and think kindness. These words are fighting words. They're assaultive and very disrespectful.
Here's a turning point. Once charges enter the conversation, this stops being about bad judgment and starts becoming a criminal matter. Courts can pursue charges if communication crosses into threats, harassment, or obstruction of justice. And once prosecutors believe the line has been crossed, the situation escalates quickly, and penalties can become very real.
Mind you, these are not small charges. And I don't even have a police report. But I'm looking at these charges. Count 1, armed robbery, is a felony punishable by life or any term of years. Count 2, weapons, dangerous weapon, carrying with unlawful intent, felony, 5 years or $2,500. Count 3, weapons, felony, firearm, pneumatic gun. I don't have what that, just apparently doesn't have what that is. Is that 2 years?
Your Honor, it's a mandatory 2-year consecutive to the underlying offense.
That part's missing. But anyways, I thought it was a 2 year. It's a 2 year. These are some pretty big charges.
This moment adds a whole new layer to the story. Accusations of weakness in a courtroom environment often signal deeper tension between the defendant and the authority of the court. Judges are extremely sensitive to behavior that undermines the dignity of proceedings. What might sound like an insult outside court can be interpreted as defiance inside it.
And it is only a small man who uses those words against a woman or against anyone. Those words do not make you strong, they make you weak. And it's very disappointing, sir. You have a mother?
Yes, I do.
Do you love your mother?
Yes.
How would you like it if somebody wrote those words to your mother?
I would not. I wouldn't like it.
Then what were you thinking?
I was angry. Case been at a standstill for a year and a half. I know it's not a good excuse, a good reason of why I did it, but I just been in a dark space mentally, just ready to get on with my life. I learned a big lesson being locked up, just ready for a resolution.
Sir, I'm here every day. Law enforcement, even on vacation, will call me. The jail will call me 24/7. I'm not unknown. Your attorney in his office is not unknown, and neither is the prosecutor's office. If you got a problem, tell the sheriff. The sheriff's going to call us, one of us, all of us, and we're going to help you. These letters hurt your case. If you think that I am going to entertain a bond after I read those angry words, those fighting words, the answer is no. So y'all can make your record. But when I look at this, I look at danger, I look at threats, a lot of anger. We're going to get this resolved. I don't know what's going on here. I think we've had a few pre-trials, haven't we?
We have a final pretrial and a trial date set. We have our final pretrial set for mid-March.
I think it's March 11th.
And now we arrive at one of the most serious possibilities in any courtroom: contempt of court. This isn't just about disrespect. Contempt can lead to immediate penalties, including fines or even jail time. If the judge believes a conduct interfered with the administration of justice, things can escalate fast. The question now becomes, will the court draw that line?
Your Honor, we will file a pretrial with a trial date in April.
So shall we have the final pretrial? And in regard to these letters, I'm thinking maybe we have contempt. These are threatening. Contempt carries with it 93 days and or $7,500.
Well, Your Honor, we are still attempting to negotiate a plea offer here. I would simply respectfully request that we keep that window open until that March 11th date. It's my understanding that Madam Prosecutor would like to meet with the complaining witness again and then extend a final offer. We have been negotiating in good faith on both sides. Certainly, Mr. Hanks' alleged statements here have added another layer of complexity here to the negotiations, to put it mildly, understated. But respectfully, Your Honor, we are making every effort. I'm making every effort on my end. So is Chief Deputy Matusco, to try to see if we can find some common ground here to a resolution before a potential trial date, which we have set. And I will be prepared and able to proceed with the trial on that date if needed, Your Honor.
Ms. Matusco, you're asking for contempt.
Your Honor, this time I would be asking the bond be revoked. We are set at $250. I believe the court rule allows it. The court did not read into the record the final statement on the final letter that I did receive in January.